Okay, so today I'm going to be going over some basics on how to prove a sexual harassment case and what it takes to prove sexual harassment. So it is a pretty extensive topic. There is a lot of case law and obviously a lot of litigation on the topic. So I'm going to go through it. Kind of systematically, like each thing that we are going to have to uh, show in order to get a sexual harassment um, case going. So in any kind of case, there's going to be what's called elements. Um, and so the elements are things that you need to prove in order to prove an entire case of the cause of action, which is sexual harassment. So I'm going to be pulling up the elements here. And these elements are under what's called the Fair Employment Housing Act of California. So that is the governing code in terms of what constitutes sexual harassment. So there are several different types of sexual harassment. I am going to be focusing on not quid pro quo, but just general basic sexual harassment. So I'm going to add it right here. All right. So the elements are that the plaintiff, and this is called the jury instruction. So it's actually pronounced Casey, CACI, and it's jury instruction 2521A. So it says that the plaintiff was an employee or an intern or someone providing services, and that they were subjected to harassing conduct because of their protected status. So we'll break this down by elements. So element one, that they worked for the employer. And it's a pretty simple element to show, generally speaking. There's obviously exceptions to everything. Section 2, element 2, that they were subjected to harassment because of their protected status. So what you'll need to show is that they're, generally speaking, sexual harassment is on the basis of gender. So how do you show that it's on the basis of gender? If the person is making gender-based comments, for example, they are focusing on a woman's body parts or a man's body parts. Another way is if the person is targeting people of the same protected status, which if they are targeting only women, like if they targeted other women before, if the person is making so in terms of making gender-based comments, they can also refer to gender-based names. So there are certain words that would be used in order to refer to a woman, and they can be extremely profane names. So we can get into more detail later on as to what kind of names those are and what qualifies. So, um, those are ways to show that it was based on, or if the person is touching the woman inappropriately. So this is things like, if they're touching private parts, um, if they are forcing, like hugs or daily uh, showing of some kind of affection, then that could show that it was because of their gender as well. But for example, if a man is uh, wanting to hug a woman and they're hugging everyone, then it would be more difficult to show that it was because of gender than if the man was only hugging a woman. Not to say that it's not a case, just saying that the defense would have that kind of fact in order to rebut what the plaintiff is saying. So the third element, and this is one that is very hotly litigated, is a specific California standard, whereas severe or pervasive. And so severe or pervasive is generally defined um, in law, and it's heavily litigated as to what it actually means, so much so that it was recently changed under government code. Changed the standard in 2019. So some of the specifics of it is that a single incident may suffice, meaning like a single incident that is severe enough would suffice. If it occurred over a substantial period of time, that would make it pervasive. And this would make it severe if it's a single incident over time. A single incident. Multiple drastic incidents would make it severe, and multiple drastic incidents over a substantial period of time would be severe and pervasive, but you only need to prove severe or pervasive, not severe and pervasive. So that's essentially what severe or pervasive means. And there's specifics as to what severe may be, maybe like touching of inappropriate body parts in one instance, or if it's pervasive, that it's like not so severe, but gender based name calling over months or years, that could be pervasive, where it alters the person's ability to work. Okay, so going into the next element, that a reasonable person in their circumstances would have found it hostile, intimidating, offensive, oppressive, or abusive. So that is element 4, reasonable person. So in the sexual harassment context, if another woman in the plaintiff's shoes would have felt the situation, the work environment, to be hostile, intimidating, and that could be proven by other women's testimony. This can be proven by mental health expert testimony, or it could be done by an HR representative testimony. You can also show by the employee handbook what isn't allowed, and you can make the argument that if it's in the employee handbook, then that's what the standard should be for men or women or the interaction in the workplace. All right, so element 5 is that the plaintiff felt. So this is the subjective standard, and this is the objective standard. And again, you can prove this through you could prove what does it mean subjective? How the plaintiff actually felt about the situation. And how would you prove it? Other witness testimony. Did they observe the plaintiff mentally distressed, emotionally distressed, crying, complaining about the situation? Did they go see a psychologist? Did they get some diagnoses that was caused by the hostile work environment? Is there an HR representative or other witnesses to show what the plaintiff complained about? And that can be very, very extensive as to how you'd go about proving that. The 6th element is probably the most litigated element, and it's establishing liability. So the 6th element says that the supervisor engaged in the conduct, or that supervisors or agents knew or should have known and failed to take immediate inappropriate corrective action. So in California, if a supervisor engages in the conduct, then that is strict liability. That means that they are liable, and now all you have to prove is just damages. So defense attorneys, insurance companies, employers, they really, really, really want to stay away from a supervisor. So what they will say is, no, this person was actually not a supervisor. They were just, a low of the totem pole worker. And we will get into that more specifically. And the second is supervisor agent knew or should have known. Then it goes to a negligence standard. So knew or should have known and failed to take immediate appropriate action. That would place in negligence. So then you have to prove that they knew it or should have known about it, that it was so obvious that they should have known, and that they failed to take immediate preventive action to prevent it from happening again. Okay, so what is a supervisor? That is defined in Government Code 12926, subsection T, and it generally means I'm going to because it's done so often, I actually know these by heart. I'm going to screenshot for you the actual definition from the Casey. So here's the definition: that a supervisor has the authority to hire, transfer, promote, assign, reward, discipline, or discharge, or effectively recommend any of these actions. The responsibility to act on a plaintiff's grievances or effectively recommend action on the grievances, or responsibility to affect the plaintiff's daily work activities. So, and then their authority or responsibility must not be routine or clerical, but must require the use of independent judgment. So, um, typically, how we go about proving that they are a supervisor is by showing that, one, they if they have the responsibility to direct daily work activities, which is typically how we define a supervisor. Yeah, the supervisor was telling me what to do all day. Then we would also show that they would be assigning duties to the plaintiff, and also if the plaintiff didn't follow their direction, then they would be disciplining the plaintiff. Typically what the defense will say is, well, they weren't allowed to promote the plaintiff, they weren't allowed to discharge, terminate the plaintiff. Um, so we show like directing daily activities, assigning duties, discipline, if failed to follow directions of supervisor, and then it's the big one, independent judgment. So what is independent judgment? It can mean um, that they do it on their own without so much input from their higher ups. So what the defense tries to do is say, they try to overanalyze it by saying, well, they couldn't exactly do anything without the authority, uh, without the direction of someone that is higher than them, who is the real supervisor. But what we do, how we prove this, we show, a shortness in time of between in decision making. So when a supervisor sees that there's an issue, they just decide what to do right after it. Um, Shortness in time in discipline. If they say, okay, well, you did this, so now we're going to cut hours, or we're going to issue a write up. How much time did it take in between those two events? And you'd also show that they uh, did not consult with anyone prior to making decisions, and that's one way that you can show independent judgment in order to prove the supervisorship. So it's a very, very highly litigated topic, um, very extensively litigated. And so then the elements 7 and 8 are that the plaintiff was harmed, that the conduct was a substantial factor in causing harm. So how do we go about doing that? First, we need to show that first we need to show harm. What is harm? It's emotional distress. How do we do that? We do it through eyewitness testimony. Just like we saw, it's going to be very similar to element 5, the subjective standard. So first we prove it through eyewitness testimony, observing the plaintiff, mental health expert testimony, HR representative testimony, and other witness statements. And then we show a substantial factor, which means more than trivial or remote, uh, generally. That we do that through expert testimony and plaintiff testimony, other witness testimony. This is, generally speaking, a totality of the circumstances. So we asked the experts, what do you believe caused Miss So-and-so's major depressive disorder, generalized anxiety disorder, post-traumatic stress disorder? They go into it and say, I believe these incidents in the workplace caused it. And we asked the plaintiff themselves, what do you believe caused this kind of testimony, that kind of, sorry, this kind of, these feelings that you have about the situation? Definitely the workplace. What the defense will do is they'll bring up previous psych history. So like, criminal history, history of abuse, um, childhood trauma, like divorce, abuse, etc. Anything that they can get their hands on. Prior workplace trauma, prior lawsuits, like car accidents, bankruptcy, other claims, workers' compensation, all sorts of stuff that they will try and get their hands on in order to prove it. But it's important to be forthright and honest throughout all these answers. But even though if a person has all these things, still, if it will be up to the fact finder, whether it be a jury or an arbitrator or a judge, as to what the amount of damages are. So after you prove strict liability, it's just a matter of how much a plaintiff is owed in order to show damages. In conclusion, I hope this is helpful. If you guys have any questions, please feel free to reach out to me, subscribe. I hope that this kind of gives you guys a better understanding as to how to prove sexual harassment in California. And I will see you next time.